Oh, good morning. My name is Justin Oliver, and I'm an attorney here at Divorce Matters. And I'm here today to answer some questions from the community about how COVID-19 is affecting divorces in Colorado. One of the most prevalent questions, common questions that we've been receiving over the last week or so is, how does the transition into safer at home phase impact people who are looking to get a divorce in Colorado? The outbreak of COVID-19 has brought about many questions and obstacles that impact all three of the primary areas of a divorce, including the division of debts and assets, the allocation of maintenance or spousal support, and issues involving children, including parenting time, decision-making, and child support. And this morning, I'm going to try to tackle a few of the specific questions that touch upon each of these areas respectively. First, the division of debts and assets. Now, Colorado is what's known as an equitable distribution state, which means courts are required to divide up the debts and the assets in an equitable or a fair manner. And there's a common misconception out there that Colorado is an equal distribution state or a 50-50 state, but that's not necessarily true unless the courts determine an equal division of the debts and assets is what's fair for the particular case in front of them. One of the biggest assets of a marriage is the marital home. And a common question that I am asked, or a question that I am asked commonly, is whether a spouse loses his or her interest in a home or their claim to the home if they move out of the marital home while a divorce case is ongoing or before it's finalized. But the short answer to that question is no. If a spouse leaves the marital home during the pendency of a divorce, or even right before a divorce, they do not lose their claim to the marital home. If the home is sold as part of the divorce, or if the other spouse keeps the home, then the spouse that moves out is still entitled to their equitable share of the equity in the home. And they actually still maintain their right to claim the home as their asset if they'd like to keep the home as part of the division of debts and assets. Another question I've been asked recently related to debt and asset division is whether debt that has been accumulating over the last few months during the COVID-19 outbreak is considered marital debt that the court will divide up amongst the parties. And the answer to that question is yes. Again, all debts and all assets acquired during the marriage that were not either a gift or an inheritance is marital and is subject to the court's division. Now, how the court divides up that debt is another question. Again, they're going to try to do it fairly, and they're going to look at a number of factors, including what was the debt incurred for, what are the financial and economic circumstances of the parties, and they will also look at the bigger picture of all of the other debt and assets of the marriage that are being divided out and who gets what. Now, one of the most common questions that our office has received during the entirety of this COVID-19 outbreak is, what recourse does a parent have if the other parent is withholding the child or the children from them during Colorado's stay-at-home order? And let me first say that the outbreak of COVID-19 in and of itself is not a sufficient reason for one parent to withhold parenting time from the other parent. Courts expect parents to continue to follow any court orders that are in place, and they also expect parents to continue to foster a loving relationship between the child or the children and the other parent, even during these troubling times. Now, there are some exceptions. For example, if turning the children over to the other parent would cause the children to be in some sort of imminent physical or emotional danger, then the court does have some options for immediate relief in those certain circumstances. Now, if you do believe your ex is unreasonably denying you access or parenting time with your children, there are a couple of options. First, you always want to try to negotiate with the other side, see if there's some sort of amicable settlement that you come up with. And then ideally, you want to solidify that in a writing and file it with the court and make it a court order. But if that doesn't work and you're unable to reach an agreement, you can ask the court for temporary orders to try to get some structured orders in place to help define parenting time for both you and your spouse to give some consistency while the divorce is ongoing. If there already are court orders in place and your ex is violating those orders by withholding parenting time, you can bring the issue before the court and try to get some make-up parenting time, and perhaps even have the court enter some sanctions against the parent that's unlawfully withholding that parenting time. Well, that does it for today and for this week's Ask a Lawyer. I hope you found these answers helpful. If you have any questions regarding your particular situation, please go ahead and reach out to us by texting the number in this video or by visiting our website below, and you can speak with one of our attorneys. We will be back next Friday to answer more of your questions. We hope you have a great weekend and stay safe out there, Colorado. Take care.